Justice Gorsuch. Justice Kavanaugh.
Just the ACLU's amicus brief expresses concern about what they call suppression by subpoena and censorship by intimidation. And they say, just go with the common sense framework that the court's cases have, which have said that a speaker is not obligated to wait for formal enforcement before challenging the constitutionality of state action, and a subpoena seeking sensitive donor information, to pick up on Justice Kagan's common sense point, can chill a disfavored speaker's protected associations long before it's ever enforced. I mean, you've gone to the specifics of the complaint, but the broader common sense of the situation reflected in the ACLU's brief, reflecting some of the questions, would seem to say, this is just kind of obvious that there's some kind of objective chill from a subpoena on speech. So I just want to give you a chance to respond to that amicus brief.
Absolutely. Absolutely, Justice Kavanaugh. We think there is certainly a difference between our position and the ACLU's position in that brief, but that difference is not as great as it might appear on its face. In particular, as we noted this morning, we think that while the issuance of a subpoena standing alone by itself isn't enough to get someone in the federal courthouse doors, you could have situations where there are other government statements or other government actions that themselves create an objective chill that might, together with the subpoena, be sufficient to establish standing. And I take it that that's really the thrust of the concern that the ACLU has, is where there's some clear factual record where the government, for example, has made statements or actions saying we're going to go after donors, we're going to publicly disclose their information, we want to target them. I think we would agree in those circumstances that they're standing. The problem is that the factual allegations just don't support that in this case.
Thank you.
Justice Barrett.